You see, I've quoted authorities that where you will talk about concurrent jurisdictions. So the Supreme Court has a jurisdiction to interpret the matter of the Constitution, and the High Court has to look at issues of the vacancy of seats. The authority is very clear that the sheer fact that the High Court has jurisdiction to look at the vacancy of seats will not oust. The word is oust the jurisdiction of the Supreme Court to interpret a constitutional matter. And let me tell you the constitutional matter here. The constitutional matter, which is very critical and is lost on most people, that can a Speaker of Parliament assume the role of the Supreme Court and interpret a constitutional provision relating to the vacancy of seat? This is what they don't want to address.
No.
But Honorable, I think the Speaker read the Constitution and was applying it per his understanding, right? So because first of all, you have to read the provision, understand it more or less, interpret it in a way that in how you understand it before you can enforce it. That is in the absence of a rival meaning. But the point, I think, is that at the time the Speaker was making the declaration, he said he had not been served with Afenyomakin's process, even though he had heard of it. So I think that point must be made clear.
Yes, when he said he's heard about a matter pending before the Supreme Court, with the greatest of respect, that statement alone should make him law-abiding and say that, can I have it before I proceed? So the Speaker himself is conceding that he's aware of matters pending before the Supreme Court, but it's not been served. Nevertheless, I will not look at the processes in the Supreme Court and go ahead and pronounce judicially matters preserved for constitutional interpretation by the Supreme Court. That leaves much to be desired.